Mr. Koopmans, you may proceed.
Thank you, Chief Justice. Felt like I was just here.
You'll be back this afternoon, too. So.
I'll reserve any remaining time I have for this afternoon, if that's all right. May it please the court, when this case came to this court for the first time in Mueller 1, there were a whole host of claims. There was a claim that we talked about yesterday for discrimination vis-a-vis MDs and DOs for chiropractors. There was a monopolization claim which alleged that Wellmark could not pay chiropractors less than MDs and DOs under the antitrust laws. And then there was another claim about a settlement, a prior settlement involving Wellmark. And then there was a, quote, price-fixing claim. Coming out of that case, there was only one claim left, the price-fixing claim. This court sent the discrimination claim to the insurance division. This court said on the monopolization claim that Wellmark can pay chiropractors whatever it wants. There is no problem with unilateral choice of payment under the antitrust laws, but that this allegation of price fixing remained. So we went back to the district court, and in that time, shortly after that, plaintiffs stipulated for strategic reasons that their price fixing claim was per se only. That is not an unusual strategy for antitrust plaintiffs. It happens very frequently because the proofs for per se claims and rule of reason claims are very different, with the rule of reason claim being much more onerous. After that, Wellmark moved for summary judgment, saying that no, this price fixing claim that they have alleged, the factual allegations of it, it's not really a per se claim. The rule of reason would apply. The district court agreed and entered judgment, complete summary judgment on the case, and plaintiffs then filed a notice of appeal saying that they were appealing from that final order. This court then affirmed that ruling, and we went in Mueller 2. And we talked then about whether the chiropractors might have a rule of reason case. And as we discussed then, if they wanted to bring that claim, they would have to do so in some other matter because they had already stipulated that this was only a per se case. The case that was then affirmed went back down to the district court. We assumed that this case was over, but the plaintiffs have now asked to add the rule of reason claim that they stipulated that they were not bringing in the first place, and the district court has allowed it. So now we are back for clarification, I guess, as to what Mueller 2 means and what finality means in this context. And of course, this case was over. This court has already ruled, and it would seem to be common sense, that once a case is completely dismissed and then affirmed by this court, that there is nothing left to do. A plaintiff can't go and try a lawsuit on one theory, go to the jury trial, the jury rules against him, go up, get affirmed, and then say, you know what, I had another cause of action too. I want to try that one instead. That would, of course, blow res judicata issues up completely and would wipe them away. There seemed to be some confusion in terms of the district court about what happened to this rule of reason claim. And the district court ruled that, well, it was kind of lurking in the background, that they didn't dismiss it, and so it must still be there. We know that not to be true because, one, they appealed, of course, as a final order. We know it also not to be true because they stipulated that they didn't have a rule of reason claim. Second,
because they stipulated to that, are they in effect trying to renege on that stipulation? I'm wondering if this is a case where judicial estoppel would apply, and that's a doctrine our court can impose sua sponte. I mean, they took a position, the court relied on that position and not staying it in favor of the insurance division, and then the case proceeded based on the stipulation. Summary judgment entered, affirmed, and now they want to argue it was kind of there all along. That seems to be a change in position, and maybe they're stopped from trying to renege on their stipulation.
Oh, it certainly is a change in position, and estoppel could have come up at some point, but we don't even need to get that far in this case because there was a final judgment. So anything they might have done or could have done then is now over. Finality rules. But Your Honor, you make a very good point, which is that at the hearing on the motion for summary judgment, Mr. Norris said, well, maybe we will allege, so this is before the court dismissed the case, maybe we will amend our complaint to add a rule of reason claim. And Judge Hutchison almost brought up that exact argument, Your Honor. He said, well, I don't really get that because you've already stipulated that away, and now we're here, so I don't think you can amend. If they would have tried to amend, the court would have denied that amendment, and then we would have been up on appeal on that issue, we would have said, no, they're stopped, and the district court did not abuse its discretion to deny the amendment. But they never moved for an amendment before the court entered final judgment, and so this case is over. There was an additional kind of issue about, well, maybe this is different because it's a class action, and that's not true either. Judge Hutchinson, in dismissing this case, didn't violate any of the class action rules. None of them apply. He dismissed the named plaintiff's claims, which by then operation of law moots the class allegations and the request of the named plaintiffs to represent a class. Now, it's very important that means that the proposed class members are not bound by that ruling, and so that's why we're coming back this afternoon to hear the other case. But it does mean that that case is over. It's completely done and can't be renewed. Assuming, I mean, we have two cases which are essentially now exactly the same. We have the Mueller case and we have the Shaquin case. Really, the only difference is that the Mueller plaintiffs are in this one, and they've also want to be in the other one, but estoppel will apply to them. Res judicata will apply to them, and so it's important that we get this case right. It also appears, we can only assume.
Is that necessarily true that they'll be subject to res judicata? Because can they make an argument under the restatement of judgments that this stipulation kind of carved out the rule of reason claims and allowed them to pursue them in another forum? I mean, I haven't looked at it in detail.
If they had a rule of reason claim based on the exact same conduct, then it would have, that claim preclusion then would apply to that. So no, they can't do that. And the other issue is, and why it's important, why we'll talk about this afternoon, is that in this new case, and what plaintiffs want to add to this case are brand new claims. Just forget a rule of reason. They want to add a geographic market division claim, which is something that has never been alleged before. And what seems to be so important to them for adding that to the Mueller case is they want to apply relation back, because they want to go back with that very brand new claim and go all the way back to 2008. That's not okay. We can talk in Shaquin about what tolling means for statute of limitations and what types of claims.
Don't they get that same effect under American Pipe anyway in the new case, or is there a distinction?
They have to be the same claims. So for American Pipe to apply, the claims in the new lawsuit that the new plaintiffs have brought had to have been told in the old lawsuit. There will be, and we will talk about this in Shaquin, I'm sure there'll be a debate about this, but there will be under American Pipe no tolling of the geographic market division claim. That claim was never made in Mueller, so it could not have been told. So the statute of limitations in Shaquin on that claim starts when they filed Shaquin.
We said in Mueller, too, quote, "We are not today foreclosing a rule of reason claim against Wellmark if it were shown that the anti-competitive consequences, et cetera, I suppose we should have said by other plaintiffs.
Right. I mean, I guess I assume that that's what that meant. It was a matter of precedent, not as a matter of in this case, and that's all it means. That's very common terminology, so I didn't read it any other way.
And ordinarily, if a motion for summary judgment is granted dismissing the entire petition and it's affirmed on appeal, that case as to those parties is over, and we don't have to say we really mean it this time.
Exactly. And if there is some further directive, I mean, here, why would there have been? Then there is a further directive. So it goes back down. Procedendo says, we are remanding the district court to consider X, Y, and Z. There was nothing here, because why would there be? Because it was complete summary judgment, completely affirmed. There is nothing left to do.
Back to American Pipe, I mean, this is sort of this afternoon's case, but why wouldn't they be able to get tolling based on the putative Iowa class action that's now part of the MDL in Alabama?
That's different than getting relation back to the beginning of filing the Mueller lawsuit. If there are no other questions, I'll bank my time for this afternoon, or we can talk about yesterday, whatever. Thank you.
Thank you as well, Counsel. Mr. Norris.
May it please the court. Mr. Koopmans statement of the facts are very much at odds with Chief Judge Gamble's statement of the facts or the facts that are in the record. This case started out after the second Mueller case with a Fourth Amended petition. The Fourth Amended petition stated a combination and conspiracy and restrained trade, and it did not state that it was a per se. It did not state it was a rule of reason. It didn't state it was a quick look. It didn't state anything other than that it was a combination and conspiracy and restrained trade. Now, what Mr. Koopmans did, and I'll give him credit for innovation, is that not despite the fact that the first Mueller case split off the case between an antitrust case and a case that should go to the Insurance Commission under exclusive jurisdiction, Mr. Koopmans says, well, primary jurisdiction is in the insurance commissioner to decide the antitrust issues under the rule of reason. Now, how is primary jurisdiction in the insurance commissioner to decide any antitrust law? You have reviewed what the insurance commissioner did, and there certainly is nothing that goes to the issue of whether or not a combination and conspiracy and restrained trade had more anti-competitive purposes than pro-competitive purposes. There's nothing there at all. And that's the only issue. The price, in a price-fixing case, the reasonableness of the price is never an issue in a price-fixing case. The reasonableness, the rule of reason has to do with, is it a reasonable combination? Now, notwithstanding all of that, which we raised, the judge indicated that he was inclined to stay the case, at which point we get into a discussion as to how or under what conditions we could go ahead with part of the case. And they come back with two pieces of paper. The first one was their response that said, well, the plaintiff says that that there's a per se violation there, but that's not how the Fourth Amendment reads. This is what the defendants are saying. They're saying the Fourth Amendment has rule of reason facets to it. All right? So I don't have to contend that. They agree. But
Norris, I mean, let's say everything you say is correct. Nonetheless, there was a summary judgment granted to the defendants, and we affirmed. Well, why doesn't that end this particular case? And then you can make all the arguments about relation back, whether there's claim preclusion, whether American Pipe in the other case.
I don't think it's claim preclusion. I think you're talking res judicata. What else could you be talking about?
But
Res
you can
judicata
fight.
means that you have to have a full and fair opportunity to litigate your case.
But you can
Now,
fight about that in the other case.
I gave them facts. I gave the judge facts as to why we have a rule of reason case. He said, I won't let you amend. Why won't he let me amend?
Did you move to amend?
I said we could amend.
But did you follow up after that?
How do I have to move to amend when the judge already told me in open court he wasn't going to allow it?
How do you get around the language in your stipulation which ends, plaintiff's allegations exclude a contention that a rule of reason analysis is applicable to the violation of law, et cetera, in the Fourth Amended complaint? Didn't you stipulate that your Fourth Amended petition had no rule of reason claim in it at that time?
You know, that's the most odd stipulation for one thing, because they never agreed to it. But the other thing is that what I agreed to was that the only way we were going to go ahead and not be stalled out for another 4 years or whatever was if we limited the case at that point to the per se.
And that's what you did, right?
That's what I did, right. But I did more than that about res judicata and full and fair ability to litigate. Into the record what the proof is of the rule of reason case. All right, I did it. So, you know, I was telling about I had a full and fair opportunity to litigate the rule of reason, if you let me.
But, Mr. Norris, why isn't that an argument for the other case? In other words, I think the defendants concede that all your clients, except the half dozen or so named class representatives, can go forward in the other litigation without any claim preclusion effect. And you have an argument as to why claim preclusion doesn't apply even as to the named plaintiffs. So why don't you fight that issue out?
Well, you know, that's precisely what Mr. Draper and Judge Gamble were saying when I offered to bring in the Shaquin plaintiffs as interveners, which under old Iowa law is a proper thing to do. Not only does the United States Supreme Court say it's proper under recent cases, the Iowa Supreme Court has said back when the class action was a spurious class action, that the thing that it holds a place for anybody that wants to intervene. All right. Well, I offered intervention, and they suggested that I file it separately. Well, I did file it separately, but I also kept the offer of intervention in this case. So I don't. It's sort of like if a plaintiff dies, then the case dies. Okay, that's pretty common law. But the fact is that you have a year or whatever to substitute in the estate. All right? Well, if the plaintiff dies, in this case the Mueller plaintiffs do, at least on the per se case, and you go ahead and say, well, the per se case was the entire litigation that was contemplated, still, you have under Iowa law and under the general law the ability to bring in substitutes to keep that case alive.
But you have to do that while the case is alive. Now, I know you've done a lot of class action work. Am I correct in understanding no class had been certified in this case?
Well, thank you for reminding me of what my central point is. I do get excited, I'll admit.
Passion
My
is
central
good.
point is that Rule 1.271.1 says, unless certification has been refused under Rule 1.262, a class action without the approval of a court after hearing may not be dismissed voluntarily. That's what they're asking me to do. They're asking me to stipulate that I dismissed everything with prejudice other than the per se. I refused. I could not do that because your rule says I can't.
I haven't done research recently under that rule. As you know, the Congress took a lot of the class action work away from us.
Yes, I know that.
And, but, I mean, isn't there an argument that that rule applies once it's been certified as a class action?
That rule applies unless certification has been refused. That's what it says. And it says, and additionally, it can't be dismissed involuntarily without an adjudication on the merits. We never were given the opportunity to litigate on the merits the rule of reason facet, which I'm sure you know, Justice Mansfield, the rule of reason in every Section 1 case. That's what the rule of reason's about. Per se is an exception to the rule of reason.
Well, at that time, wasn't Judge Hutchison trying to identify what the claim was before the court that was part of this motion for summary judgment that the judge had to rule on?
I don't think Judge Hutchison was trying to identify the claim. he thought that the plaintiff's motion to stay the case was good. And that's where the discussion turned on, well, there is, the plaintiff has emphasized that there is a per se case in there, and that could go ahead because the insurance commissioner would have no say on a per se case. There's no issues for the insurance commissioner to decide. That's assuming, of course, that there would be issues for the insurance commission to decide in a rule of reason case, which is not the case at all. I mean, not only did he not decide it, I mean, there wasn't even any request for him to decide whether or not a combination and conspiracy between Wellmark and self-insureds and the out-of-state blues was a combination and conspiracy in restraint of trade. There was no such issue. The issue before the insurance commissioner was the price correct under 514F. Price is never the issue in a rule of reason case.
But when Judge Hutchison was entertaining this motion for summary judgment, it appeared that he was trying to identify what the issue was that he was asking to rule on, and he was directing, asking for help from the lawyers. Tell me what's before the court. And it seemed to be that's when this stipulation or the discussion occurred, as whether it's a per se claim or whether it's a rule of reason claim. Only for the purpose of the judge trying to decide, what am I ruling on here? And
well, I think the fact is,
so you weren't bargaining away any claims. You were we're trying to identify in a court proceeding, what's this lawsuit all about?
well, I think the fact is, as I stated, that the defendants, before all this discussion in this hearing that's not recorded, the defendants said there's rule of reason allegations in the Fourth Amendment. I agree, there were rule of reason allegations in the Fourth Amendment. Okay, so what are we going to do about it? The judge is going to stay the case if there's rule of reason allegations. Well, so it finally turned out that he didn't rule on the stay because the defendants, after they got the stipulation, said, well, you don't need to rule on it. They didn't dismiss the motion to stay. The judge didn't dismiss the motion to stay. It just got tabled. I apologize for the fact that I'm obviously personally involved because I decided what needed to be done to keep this case going. And I'm a little heated about it. I'm not yelling at anybody, although I know it probably sounds like it. But at any rate, you've heard my point. Judge Gamble, as far as I can see, had jurisdiction to decide because he has original jurisdiction. And there's nothing wrong with what he found. Now, last time I checked.
Hey, Counsel, if I could, just ordinarily, if a petition is dismissed on summary judgment and the summary judgment is affirmed on appeal and there's no pending motion to amend, isn't the case over?
No,
period?
because of course you well recognize, being a very experienced trial lawyer, that there is partial summary judgment.
But this wasn't called a partial summary judgment, and it dismissed the Fourth Amendment petition.
Okay, but in effect it was. And your rules on taking appeals, certainly it says final judgment, but you have a rule in there. I wish I had it in front of me because it struck me that you have the ability to say any case is anything as far as appeal. You can take a case like mine where I think it was final as to that issue. It was final as to that issue. All right, you can take that case and say, well, we're going to decide it because it's an interlocutory appeal. Or you can take it for any reason you want to and not say anything. I don't know what you guys thought. I know what Judge Mansfield said. He said, we're not deciding that there's a rule of reason case there. I don't
but we
think
were
that-
affirming.
I don't think that's particularly the point I want to stand on.
Right. But I think we did affirm, as I think Justice Waterman is trying to draw out with his questions, we affirmed what appeared, I thought, a grant of summary judgment dismissing the petition.
Well, I mean, the record certainly had in it that I was trying to raise the rule of reason case. I mean, it was there. It was there in that record. So I think Judge Gamble was right. Thank you.
Mr. Norris, thank you as well as for your parenthetical comment. This is advocacy, and that's why we're here. So thank you. Mr. Koopmans.
Chief Justice. Mr. Norris certainly did raise in the district court that he thought he had a good rule of reason claim, and then there was a specific discussion about that with Judge Hutchinson about whether that claim still existed in the case. I disagree, we disagree, I think, as to all the meaning of the stipulation, all of these things, but the only real point is if that claim really was still alive, or if Judge Hutchinson was wrong to tell plaintiffs that they would not be allowed to amend their complaint, their petition, to add a rule of reason claim, then that is an issue that had to have been raised in Mueller 2. District court erred because he said we could not amend, or more pointedly, they would have had to try to amend and then appeal the denial of that amendment, all before final judgment was entered. And kind of what the difference is between a rule of reason claim and a per se claim. It really just comes down to a matter of pleading. So in Iowa, we have very general notice pleading. So say I am bringing a claim under the Iowa Competition Act under the equivalent of Section 1 of the Sherman Act. That's all you really need to say. Whether it's a rule of reason claim or a per se claim depends upon the allegations and can go forward, and we can discuss those things later on. And that's exactly what happened here. They put meat on the bones of their claim. In federal court, though, you do, because you have to tie your allegations to the actual claim, you have to say, well, we're bringing a per se claim, or we're bringing a rule of reason claim because here's what we're doing. We're pleading this geographic market, this product market. So yes, in the beginning, and why we said this claim that they're pleading, this anti-competitive action, this Sherman Act Section 1 claim is a rule of reason claim. They disagreed. They framed the claim. They told the court what kind of allegations that they were going to bring, what kind of proof that they were going to bring, and that established what the case was about. And Chief Justice, you're exactly right that Judge Hutchinson was doing exactly that, was confirming his understanding of what was happening in the case, what claims, what allegations were left, and it was only that there was a per se violation, which meant that plaintiffs only said that they were going to prove that there was an agreement and that legally it was a per se violation. That was all they had to prove. They didn't have to prove any of the other things that we'll talk about this afternoon. And so the claim in the case was very different after that stipulation.
So Mr. Norris had brought up our Rule of Civil Procedure 1.271 governing dismissal and compromise of class actions. Now this case had not been certified as a class action. The next sub-provision says if it has not been certified, you don't have to give notice to class members regarding the dismissal, and the court can decide what notice, if any, goes to people beyond the named parties. But is there anything about the fact that this was captioned as a putative class action, although not yet certified, that affects the finality of the summary judgment motion for the named parties?
Not how it proceeded here, and really for the named parties, not ever. And so the procedures that are put into place in these rules in 1.271 and beyond are always to protect unnamed class members. And because they never became class members, they were therefore not bound by the ruling, and therefore they need no further protections and don't have any. But the case is gone, and what their option then after that is they have to bring their own claim, which they've done, their own case.
Because we've routinely affirmed summary judgments dismissing petitions that started out as a putative class action not yet certified, and then we hold if there was a pending motion that or the trial court says a motion to certify is moot because I've now dismissed the entire case.
Exactly. And if a case was left wide open anytime that a class allegation was there, we would have a lot of open dockets in this court, because it frequently occurs where plaintiffs will bring a class action. They will tag on just kind of a generic class action allegation on the end. Really, though, the case is never ends up being litigated as such, even though the class claims were never formally dismissed. But once the named plaintiff's claims are dismissed or judgment is granted against them, the case is over. It is, of course, the case where if for some reason a plaintiff brings a class action and that particular plaintiff has a problem with their claim, maybe they miss a statute of limitations or something very unique to them, that the court will say, you are not a proper named plaintiff, your claim is bad. I will, though, allow, before entering final judgment, the opportunity for there to be substituted in someone who would be able to carry this torch. In this case, that didn't happen because, of course, the argument that we presented was that no one could ever bring a per se claim. It wasn't something that was unique to the named plaintiffs. So that ruling was, that argument was accepted and final judgment was granted, and there was no request to intervene before final judgment. Thank you.
Mr. Koopmans, thank you as well. And Mr. Norris, again, thank you. The case is now then submitted to the court. We'll see both of you again after lunch, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.